When creating a land trust, one of the first steps is to name the trustee or trustees. Why this person or these people? It's crucial to select someone trustworthy and capable, as they will play a significant role in the management of the trust. Who should I use as my trustee? This is one of the most important decisions in the trust creation process, because the trustee is the human being who actually owns the property under the law. The trustee is a very powerful person. Under the terms of our agreement, they will be allowed to purchase and sell property, option to buy and sell, hire management, subdivide, sell on terms, take back financing, lease property, and more. In other words, the trustee has all the legal powers related to the handling of the trust assets. But this acts in our favor because a judge would be more interested in knowing who the beneficiary is and be more likely to invalidate the trust if the beneficiary had retained any of these powers. The trustee is bound by the responsibility of fiduciary, which means they can only act on behalf of or for the benefit of the person as who are the beneficiary IIEs of the trust. To act in contravention of the trust agreement would be illegal. Most states have extremely strong laws against breach of fiduciary. The reason is that when someone is acting for another, it is traditionally for widows and orphans. Hence, if the trustee were to steal or otherwise act illegally, the state has strong laws to get the charlatans. I'd like to say that you should use someone you trust as trustee. Sometimes this is a real problem for some people because they don't trust anyone. One way to solve the problem is to act as trustee for someone else if they will act as trustee for you. Another way is to record some type of instrument, like an affidavit of interest, option, management agreement, etc., against the property using your name or the name of your corporation or other entity. If the trustee were to attempt to sell the property, anyone with a non-satisfied lien against the property would be contacted so that the lien could be lifted or satisfied to allow the sale to go through. Either factor would foil any unscrupulous trustee. A trustee can also be an officer at a financial institution. However, individuals as trustees are easier to manage and a lot less expensive. Remember that the trustee's powers are all-inclusive and far-reaching, so be careful who you choose. The documents contained in TGGF's Land Trust Document Packet actually have built into them a place to name a successor trustee, so that if anything were to happen to the initial primary trustee, no further court recording would be necessary because the successor had already been named in the recorded deed. The note: when purchasing a property, always remember to purchase in your name, placing the words and/or assigns after your name, especially on the signature line of the real estate purchase and sale agreement. Don't be concerned about the typical realtor contract, which does not allow assignment. Why? Because your handwritten and/or assigns after your signature will take precedence over the pre-printed clause, which does not allow assignment. This should allow you to close in the name of the trust. What should I name my trust? Let's start with the understanding that only one piece of real estate should be in each trust. This has the benefit of potentially only exposing one asset to the attack of creditors who are attempting to get a judgment against this one trust. If only one piece of property is in the trust, only one can be taken if a sale to satisfy a judgment is forced. Naming the trust allows you to be as creative as you choose. You have the right to name the trust anything you see fit. It will not be confused with any other trust because the trust asset will be unique to that trust. The primary beneficiary or beneficiaries shall be: who should I use as beneficiary? Of course, the first thought is that we all want to be the beneficiary of our work, but that is not always best. If the courts were to pierce the trust and the beneficiary for all the trusts for both spouses, then we haven't achieved any safety, because the lien would rest against all the property of the spouse who was judged against, or both if both were judged against, and it would still be liened if held jointly. But only one spouse was the subject of the lawsuit. On the other hand, if we name the husband as beneficiary of approximately 1/2 of the total number of trust assets and the wife as the beneficiary of the other half, then we have achieved separating the possibility of the judgment going against all of the family's assets. We have also achieved the first step in estate planning, i.e., avoiding probate, and the first step in creating estate tax savings. In any case, if you or your spouse intends to take the tax benefits, one of you should be the primary beneficiary. Form note. The names of the primary beneficiary IEs will be needed in order to complete the Declaration of Trust and Land Trust Agreement form. The percentage of the beneficial shares shall go to Y. You'll need to decide who is going to get what, the beneficial interest in the land trust, and when, upon whose death, etc. Land Trust Creation Information Worksheet annotated. Continued. The successor beneficiary or beneficiaries shall be, I think it makes good sense to have the secondary or successor beneficiaries shown in the land trust unless and until you create a living trust. You can have as many as you like, arrayed in any order you choose and on any conditions you make. Remember, these are so-called flow-through trusts, which means the proceeds and tax ramifications and/or benefits flow through to the primary beneficiary, IEs, until they pass away. Then, the proceeds of the trust flow through to the tax returns and pockets of the secondary or successor beneficiaries, avoiding probate. Form note. The names of the successor beneficiary IEs will be needed in order to complete the Declaration of Trust and Land Trust Agreement form. Have I clearly defined who gets what percentage at the death of any subsequent beneficiary? Be sure that you take special care to clearly define who gets what at the death of each of the beneficiaries. The trust director shall be optional. Why? Well, the typical use of a director is in a guardianship where the parents want to have a family friend or relative take care of the child or handicapped adult, but they don't want this person to have legal access or responsibility for the assets of the trust. The use of a director can add another layer of protection. Here's how it works. The trustee must always stand idle based on the trust agreement contained herein until told what to do by either the beneficiary or director, or until the beneficiary dies. If a director is in place, then the trustee cannot take direction from the beneficiary unless otherwise agreed in the documents. Who to use as director is another matter. The director gets to be completely anonymous as far as any recorded documentation goes. It could be that if a judgment were to be issued against the beneficiary of a trust, the director would still be the one who directs the trustee as to whether or not to distribute funds to the beneficiary. Hence, if no money is distributed, there is no money to pay the judgment. You need to have a record of how you or anyone handling your affairs after your death will be able to contact the director, include any telephone numbers here as well. The Declaration of Trust and Land Trust Agreement document provides for the opportunity to use a director. If you don't see the need at this time, just leave this area of the document blank so that one could be appointed later. To accept title, the trustee shall be paid a specified amount. The trustee shall be paid annually a certain amount as well. In order for a contract to be legal, consideration for the services must be mentioned. I feel $100 looks fair and does not look too nominal. If you were ever forced to let a judge see the document, it looks more like an arm's length transaction if it's $100 or more. But this is just an opinion. Form note. This information will be needed in order to complete the declaration. The trust address shall be designated specifically. Why? In order not to burden your trustee and to keep a handle on anything regarding the asset of the trust, it is best to have a separate mailing address for your trusts. The best method is to get a suite at your local private mail facility. This provides a mailing place for any of your trust information to come to, and as beneficiary, you would have the authority to open the mail of the trust. Form note. This information will be needed to provide the proper mailing address to the closing agent, clerk of the court, insurance agent, tax collector, notification to lender of appointment of management, notification to lender of establishment of trust, etc. The trust successor. Trustee shall be Y. Well, this allows you to have a backup. The trustee is already recorded on public records. If your trustee could not serve or could not be found, you would have a backup who could serve as trustee to sell, mortgage, etc. the trust asset. Just a quick note on the form. This information will be needed in order to complete the appointment of successor land trust trustee form. The land trust's asset shall be, since this is a land trust, you would have as the trust asset only some type of real estate such as raw land, a single family house, apartment complex, warehouse, shopping center, or office building. Remember, it is best to only have one property or tract per trust. This serves to segregate the assets and help limit exposure to liability. Form note, the legal description of the property will be necessary in order to complete the declaration of trust and land trust agreement and direction to land trust trustee forms, asset location or address county. The seller chart grantors and then os sawines is how in names as shown on the prior deed. If you or your entity currently own the property, then you are the seller's sawar house grantor. If someone else is selling their property to you or your trust, then they are the seller's sawar grantor. Form note. This information will be needed in order to complete the deed into land trust or warranty deed forms. Are there any loans or liens you are taking the title subject to? Loan number, address, phone number, contact person. The warranty deed states that the trust is taking title to the property subject to the existing mortgages, not assuming and agreeing to pay. Form note. This information will be needed in order to complete the direction to land trust trustee and warranty deed forms. Show the name of the current lender, loan number, lender's address, phone number, and, if available, the name of a contact person that you have spoken with. Form note. This information will be needed in order to complete the direction to land trust trustee and warranty deed forms. Keep this worksheet with your land trust documents. The Filled-in Land Trust Creation Information Worksheet is a very handy document containing all the answers in one place. I suggest that you keep this form with your trust documents to provide quick answers when you or someone else needs them.